Hi, I'm Louise Nixon. I'm co-founder and CEO of Quadro Counsel. I'm president of Quadro Benefits Law Group. I've been involved in pension division and Quadros since 1994. I've represented retirement plans and also the parties throughout those years. The talk today will focus on defined benefit plans. What are the most important things to know? How are they divided? What sort of discovery strategies are needing for finding and naming the plans? Identifying the issues, surrounding issues, and the remedies to those issues. We're going to cover it all. So here we go. So here's just some general, more detailed information on defined benefit plans. They're generally accrued. It's accrued benefit. It's paid monthly over a lifetime, unless it's a cash balance plan. There's no value to a defined benefit plan until the participant actually retires. So the value of the plan occurs, and determining the monthly benefit occurs at the date of commencement of the benefit by the participant. And one of the most important things to know with a defined benefit plan is whether the participant is retired and receiving a monthly benefit, or if the participant is active. The most common division method throughout the United States is the marital fraction. It's also referred to as the time rule formula. However, there are some union plans where you wouldn't want to use the marital fraction, or the plan won't allow it. The standard case law in California for the authority for the marital fraction is Marriage of Brown, and also Marriage of Gray contemplates marital fraction, but also other division methods. The other important issue that comes up when we get the calls on is that if the participant's not vested, do we need to divide the benefit? And Brown looked at the vesting issue and held that a participant did not need to be vested to award the alternate pay and interest in a defined benefit plan. Just generally speaking, a participant will vest in a defined benefit plan after 5 years of service. So if the employee is a participant's been working for more than 4 years for an employer and that offers a defined benefit plan, chances are the employee is vested. If the employee just started working there, chances are the employee is not vested. But that does not impact the end result of needing to deal with it in the divorce. If the participant never vests, then, for instance, leaves employment unvested, then there is no amount payable. The participant doesn't get anything. So it's no harm, no foul. But if the participant vests during a lifetime, then the alternate payee would be entitled to receive, albeit a small, marital or community property interest in that defined benefit plan. The other big case for defined benefit plans is Marriage of Lehman. It's a California Supreme Court case which held that the non-member spouse who owns a community property interest in the benefits owns that community property interest. Excuse me. Owns that community property interest as subsequently enhanced, which makes sense in a lot of ways because for a defined benefit plan, the value is determined at some later date. And that value at a later date, the whole point of a retirement benefit is that the value increases over time. So you get a larger benefit at a later point in time. So it makes sense that the majority of states have determined that the non-member spouse should be entitled to the value of any increased interest and increased benefit in that defined benefit plan. So this is a case for California, but there are other states, the majority of states do agree with the holding in Lehman. So there are two types of defined benefit plans. One is a traditional pension or retirement plan. And that pension, this is the vast majority of plans that are defined benefit plans, is a pension plan that provides a specific predeterminable amount of benefits to a participant at that individual's projected retirement date. So usually the benefits are based on a formula that incorporates the participant's years of service and final average compensation. And again, the benefit is generally a monthly annuity. How do you divide defined benefit plans? Most states will divide using a marital fraction, which is also referred to as the time rule formula. And so it's 50% of the marital fraction. It defines the marital interest. What is a marital fraction? It's generally the number of months of service performed during marriage over the total number of months of the employee's service through retirement. Just another brief explanation of the marital fraction, because I know it trips people up, is, so for instance, if the numerator in this fraction is the time during the marriage, and the denominator is the total time, so after the marital division date, the participant continues to work, continues to be employed, that fraction is getting smaller, right? 1/8 is smaller than 1/4. So the fraction is getting smaller, but the value of the pension is increasing. And that methodology is used basically across the country in terms of trying to determine and come up with a value for the marital interest, because there is no value until date of retirement. And like I said at the beginning, the division of retirement benefits is not perfect. Okay, this is the law. If you go to court on this, you will lose because the marital fraction is the standard. There's case law all over the place on it, but it is a hard concept to understand, especially for the participant who's thinking, "I'm still working, and he or she is getting a share of what I'm making after," but that's not the case. The share gets smaller, the value of the pension increases. The second type of defined benefit plan is a cash balance plan. That is it gets confused with a defined contribution plan. It has many of the features of a defined contribution plan, but it's not. It's a defined benefit plan. And I think the reason for the confusion is because a cash balance plan generally will provide a monthly or quarterly statement, just like a 401k. And I've actually seen companies that have on a statement the 401k balance and the cash balance plan balance, and treat them as, all in one statement. And that's a little misleading because they're different types of plans, different vehicles, different ways of dividing them. And just on a side note on plans, is that most mid to large employers offer both a defined contribution plan and a defined benefit plan. And one of those two plans is often missed, which I covered earlier, but I just thought I'd say it again. What is a cash balance plan? It's a sum of money that the plan maintains for an individual employee's account that's a hypothetical amount. And so it's an estimate, basically. And in terms of growth, it's not based on the stock market in terms of how it grows. It's based on interest credits that are determined by the plan trustees. So it functions differently, and it's divided differently than a traditional defined benefit plan and also a defined contribution plan. The features of a cash balance plan is that you can receive, and the alternate payee can receive, a lump sum amount, cash out, which is great. A lot of them will choose that option. But they also can choose to elect a monthly payment over a lifetime, just like a traditional defined benefit plan. So it has both features. There are a lot of, well, not a lot, but there is a trend for the traditional defined benefit plans to convert to a cash balance plan because it's actually easier for the plan to administer and also more cost effective for the plan. So just be aware of that because some plans are in the process of converting, and so will require different quadros depending on where they are in the process. Some offer a division where the traditional is divided one way and the cash balance it would be divided another way. So if we're in that murky area where it's converting from traditional to cash balance, or they have converted and they're still keeping the traditional, there could be additional issues that come up. But the most important thing to know in terms of the award for the divorce judgment is how you treat a cash balance plan. A lot of times we see in divorce judgments where the marital fraction or time rule formula is used to divide every type of plan. That's very common. And it's not always the best division method for the defined contribution plan and for a cash balance plan. You want to follow these are 4 examples of what would be in most cases the best way to divide a cash balance plan. Similar to a defined contribution plan, the most common award is 50% as of the marital division date, which in California is date of separation, plus applicable interest or credits thereon. It's not based on the stock market. You want to say interest credits. The other common award is an amount, if the parties have agreed on amount, which is often used in some sort of equalization and offset, as of the marital division date, or if it's an equalization and offset, it'd be as of the valuation date, plus applicable investment interest credits. If the whole account is community property, then it could be percentage as of date of segregation, plus interest credits, and likewise an amount as of date of account segregation. So these are your 4 best choices, and I encourage you to use this language if you're dividing a cash balance plan in your divorce judgment versus using the marital fraction or time rule formula. So there are 2 different types of quadros that are used to divide a defined benefit plan. One is a separate interest quadro. When do you use that? A separate interest quadro is used when a participant is not yet retired and receiving benefits. So that covers a participant that is still working or a participant that hasn't say they've left employment, but they haven't started receiving a monthly benefit. The separate interest quadro ensures a lifetime benefit payable it's based on the alternate payee's life. It's actually adjusted based on the non-member's lifetime. The alternate payee basically steps into the shoes of the participant with a separate interest quadro, gets all the benefits of what a participant would get, except that the alternate payee, if alternate payee remarries, cannot elect a joint and survivor annuity to be paid over alternate payee's life and a subsequent spouse's lifetime. So that option is not available. That's under ERISA. That's under the law. But generally speaking, most of the benefits for a separate interest quadro, or most of the benefits that are offered to a participant are offered to an alternate payee. When can the alternate payee start to receive the benefit? Generally, it's payable as of the participant's earliest retirement date. which is in most cases age 55. However, in particular with cash balance plans, many plans in their plan rules will elect an earlier withdrawal with a separate interest quadro to the alternate payee. But that would be plan specific, and that would be information that would be provided to the alternate payee after the quadro is done. The one important point to make with separate interest quadros or with any quadros is that they should be done ideally, best practice, never happens, but we're trying to change how it's done, is to draft the quadro, get it filed, and have it filed concurrently with the divorce judgment. I think there's some preconceived idea that the quadro doesn't need to be done until a later date, until participants closer to retirement. In many cases, the parties don't realize that this option of a separate interest quadro is available to them, which honestly, it could impact negotiations in the actual divorce with regard to support in particular. So if the alternate payee could start receiving his or her share of the pension at an earlier date, it may offset or create a different situation in terms of the amount of support that's ordered. So these are just things to look into, and good to know the parameters of a separate interest quadro. But the most important thing is get the quadro done. Do not wait. Because there is this period of time that usually occurs between the date of judgment and the date the quadro is done. Sometimes the period of time is a decade or more, if the parties were younger when they divorced. And in that period of time, if there's a death or if the participant retires, the non-member spouse is not protected with the divorce judgment language. It's very important. It can impact the rights of the non-member spouse if you delay getting the quadro done. The second division method is a shared interest quadro. This is a type of quadro that's primarily used when a participant is already retired. There are some union plans that will require a shared interest quadro, but it's rare. Most of them will go with a separate interest quadro if the participant's still active. What the shared interest quadro does is it provides the alternate payee with a right to a share in the participant's stream of income with the annuity payment once the participant retires. The other feature that does come up sometimes is some of the plans will allow for a successor alternate payee, so that if the alternate payee dies, then funds can be paid to that successor alternate payee that rather than revert back to the participant. The successor alternate payee must be a child or dependent in most cases. If there isn't a successor alternate payee that's eligible, or the plan will not accept a successor alternate payee because there is some murky area in the law on that, and it depends on how the plan interprets ERISA, whether they allow successor alternate payees, then the funds, if the alternate payee dies before the participant, they revert back to the participant. So when do you value a defined benefit plan, or do you even need to? I would say that the reason that people will value a defined benefit plan is if they're contemplating some sort of equalization and offset. If they are, an actuarial valuation must be performed. And Quadro Council does those actuarial valuations. Sometimes the parties just want to know what the value, the present day value is. But it's important to know that these are not guaranteed numbers, that these are just estimates of a present day lump sum value that the parties can come up with to offset against some other asset. I would say the most common fact pattern we see with offsets for defined benefit plans is when they're the two largest assets. There's the home, the marital home, and there's a defined benefit plan. The participant wants to keep the defined benefit plan. The out spouse wants to keep their home. They come up with a value for the home. They come up with a value for an actuarial present day value for the defined benefit plan, and you can do the offset that way. But again, it's important to know and tell your client when these valuations are done that the numbers are estimates, and let's say there's some number of $1.5 million for the value of the defined benefit plan. I get the questions, well, aren't I going to get $1.5 million? And the answer is no. You're only going to get a monthly payment over a lifetime. This is just the present day actuarial valuation to come up with a number that is good enough to negotiate an offset. So the biggest area of malpractice that we see with regard to valuations of defined benefit plans are with public defined benefit plans. There's a difference between the actuarial present value of a defined benefit plan and the employee contribution accounts for public plans. So generally speaking, most public plans, an employee will be making a small contribution from his or her salary towards that public plan. Contrast that with a defined benefit plan for a private company. Employees do not make contributions. The employer makes all the contributions. And honestly, I think that's why defined benefit plans for private companies are often missed, because family law attorneys, divorce professionals will look at the W-2 statements. They'll look at, and you'll see a deduction in that statement in their pay stubs of what has been paid towards some sort of 401k or retirement plan. So they say, oh, this is the plan. We know it's a 401k, but they miss that the employer also offers this defined benefit plan, and that's the $1 million asset. So that's just a little side note on to watch out for those defined benefit plans for private employers in particular, because you will not find records or information on those defined benefit plans easily. Of course, Quadro Counsel, if you come to us or we work with you or you have a subscriber, then you can look up in our database and get a list of all the plans that are offered by that particular employer. So these statements show the amount of the employee contributions, but what happens, and I have seen this and other Quadro professionals see this, and it's not like it doesn't happen. It happens often. It happens. The employer contributions are offset against the other party's 401k. So let's say there's $40,000 in a statement from CalPERS that are in employee contributions. The parties think that's the value in the account, and it's not. And they offset that against a 401k that's owned by the other party, and the other party gives up their right to that defined benefit plan. So one of the biggest malpractice issues is the valuation of a public defined benefit plan. Defined benefit plans by private employers are entirely funded by the employer. But public plans, in most cases, the employee contributes a minor amount from his or her salary to the retirement plan, and an employee will get a statement showing the amount that the employee has contributed to that particular retirement plan. What we see happening, and if somebody catches and reaches out to me before they actually come to an agreement or file their divorce judgment, is what we see is the parties agreeing to offsets or between the CalPERS plan and say the opposing party, the out spouse's 401k plan. So let's say the total amount of contributions that the employee has contributed to, and I'm going to use CalPERS as an example, California Public Employee Retirement System. So employee contributed approximately 100,000 to the CalPERS account to date, and the non-member spouse has a 401k with approximately the same amount, let's say 100,000. So they could decide that each person keep their own plan and call it a day. But in reality, the CalPERS plan is worth millions of dollars. And unless you do a present day actuarial valuation to determine what that amount is, the present day value of that defined benefit plan, you wouldn't know the total value, actuarial value of that account. The malpractice happens because the parties and or the divorce professionals involved with the case think that the value of the account is the amount of the employee contributions, and that is not correct. The next slide will illustrate that, I think, hopefully to drive that point home. Just in terms of generally valuing defined benefit plans, it's always best to do in-kind equalization and offsets. It's less risky. So if you have two defined benefit plans with both parties having one, it preferably retired, because then you know what the actual value is, then that is when I see offsets happen. But there are problems with offsetting defined benefit plans because of the survivor benefit issues that come up. And if one offers survivor benefits, the other one doesn't, et cetera. There could be other problems. And so unless it's a really short marriage, we generally don't see offsetting being done with defined benefit plans because there's too much at stake for both sides in terms of the potential windfall from one side or the other. So here's an example of, this is a CalPERS statement that an employee would get. And you can see in the total, in the top right-hand corner, the employee contributions approximately 167,000. That is what is mistaken as the value of the plan, and that can lead to problems with offsets, equalization and offsets that the parties may want to contemplate. The monthly benefit, which can be calculated with as part of the actuarial valuation, if the participant retired at age 55, is about $4,500 a month. That is not on the statement. But that would have to be done. CalPERS won't. They'll provide actually an estimate of benefits to the member of the total benefits, but that is or an actuary or quadro counsel can provide that information to you to get an estimate of what the benefits would be based on when the member is going to retire. But if you do a present day valuation of the account, the actual value of the account is $1.14 million. That's quite a difference. And so that's why I've highlighted it with this actual statement to show you and contrast the difference between determining between the parties that the value of the account is $100,000, $167,000 versus the actual value, present day value of the participant's CalPERS plan, which is over $1 million. So a lot of times for some parties that want smaller plans, so small companies will have one-person or two-person plans. And those are, of course, follow the same rules. They can be divided, they would be divided the same way as a typical defined benefit plan. If you have a small plan, 1 to 2 person plan, to get information on that plan, the person that is filing the 5,500 forms, the third party administrator that set up the plan for that employer, that's who you want to be in contact with. That's the person or the company that has the information on the plan. They would be the contact to send any quadro for pre-approval and to work out any potential issues that could come up with funding for those types of plans. There's a lot of, when it's a 1 or 2 person plan, there's a tendency to treat the plans as a defined contribution plan. It's just funds in a giant trust fund. And so that you have to be really careful of that because they're defined benefit plans. They follow the same rules under ERISA. The plan follows the same rules of having properly funded. It's one giant trust fund that has 1, 2, 3 participants in it. But it's not an individual account like a 401k for that particular individual. And so I think that's what confuses parties when they get the 1 or 2 person plans. Most 1 to 2 person plans do allow in their plan rules for a lump sum payout with a quadro to an alternate payee, or the alternate payee can to take the funds over time. But just FYI, I think the biggest problem with the smaller plans is identifying the plan with the correct plan name, because a lot of times we see it listed under the custodian, under some bank account where the funds are being held in trust. And then also working with the TPA to come up with the division that's most fair for the award. We wouldn't get involved with this, but there could be plan fiduciary issues with funding, whether the plan is overfunded or underfunded. There's documentation that has to be taken care of, and all of that is administered by a third-party administrator in most cases. So you can get that information and flesh that out. It's important to know how you want to divide these smaller plans before divorce judgment, especially if there's an issue with overfunding of the plan or underfunding of the plan, because there could be a potential post-judgment issue where one side will end up unfairly with less or more than they are entitled to under marital property law. And I could give a whole talk on just this issue, but we're just going to leave it at that for today as an issue to spot if you're dealing with that, and who to go to flesh out the funding and make sure that the plan has been properly funded. And I threw this slide in. PBGC, you hear talked about, you hear the reference to it. It is a federal agency, the Pension Benefit Guaranty Corporation, that administers defined benefit plans governed by ERISA when those plans are terminated. In many cases, that occurs as a result of bankruptcy. The same benefits are guaranteed for an alternate payee, and they're paid in the same ratio that the benefit would be paid to the participant. It's usually it's a reduced amount, mostly due to the bankruptcy. One example is United Airlines, where I've dealt with PBGC a lot because they declared bankruptcy and froze their defined benefit plan, and it's being administered by the PBGC. But generally, you treat the PBGC as a plan administrator like any other plan, and you can get pre-approval and go through the process. But it's just important to know that those plans can be divided, and to always keep the PBGC updated on your current contact information if you do a quadro with them. So the last section we'll talk about protecting survivor benefits, which I've touched on throughout the talk, but it's important enough to have a whole section on it because bad things happen when survivor benefits are not protected, and particularly for a defined benefit plan. And there's usually happens where there's this window post-judgment between the date of judgment and the quadros entered when the participant dies, the non-member spouse, the alternate payee can lose a right to a lifetime benefit. And this is because of the way the law is working, and I've talked about it before, this conflict between plan law, federal law in most cases, or state law, like the laws for the public employee plans, et cetera, that will preempt state domestic relations law. So even if your state law specifically protects survivor benefits, if it's not in the divorce judgment, you may lose it. These are the sections under ERISA for survivor benefits. That is, if you want to know about them, you want to look it up. The default for the federal law went to great lengths when they enacted ERISA to protect the rights of a spouse or surviving spouse and a former spouse through a quadro. And these ERISA sections, 205A2 and 205A1, and I gave you also the U.S. Code sites, are what establish a survivor annuity pre-retirement and a survivor annuity during retirement. The default for any ERISA federal employee survivor annuity is 50% of whatever the participant would have retired with on the date of death. So participant dies, if participant had retired on the date of death, he or she would have received $1,000 a month. Under ERISA, the default survivor benefit and the only survivor benefit for a pre-retirement survivor annuity is half of that. So the surviving spouse would receive $500 a month for the rest of his or her life. That same concept, those same rules apply in a quadro for a former spouse. So these are just good sections for you to know about. Here's the section in ERISA that allows for the former spouse to be designated as the surviving spouse in a quadro. And that's really the only way that the former spouse will be allowed to have a lifetime benefit. If the survivor benefit is not specifically stated in the quadro, then the non-member spouse, the former spouse, could lose the right to the survivor benefit. And I threw this case in, if the participant dies before retirement, it's Hamilton. It's a really great case if you want to do a deep dive on ERISA and survivor benefits. It's actually kind of a fun case to read. It's easier to read than some of the other ones. But the point is that the spouse is protected over beneficiaries. So if the participant dies before divorce, the spouse will get the qualified pre-retirement survivor annuity. It does not go through probate. It does not go to beneficiaries. It will not go to the kids. So good case for you to know about. The other lead cases that deal with divorce, and also the code section in California that deals with divorce and award of survivor benefits, are on this slide. The Family Code Section 2610 is the code section in California that specifically includes survivor and death benefits as part of the community property. But as I said earlier, if it doesn't matter what the actual code section says, what the actual state law says, if it's not stated in the divorce judgment, or if the quadro is not done before death, Then these cases, Carmona, which is a federal lead case, and Paget, of course, applies in California. Carmona follows what almost the majority of cases in the United States follow in terms of their interpretation of ERISA. The lead case is a case called Hopkins in the fifth district, which is cited in Carmona many times because they followed Hopkins, and most states will follow Hopkins. And in that case, and in Paget, it was very clear that unless the divorce judgment specifically awards survivor benefits, you cannot get a post-death quadro. And that would be the goal here in the event of death and the quadro is not done. So that's why it's very important to award survivor benefits in the divorce judgment. Have I said that enough times? I hope, I keep saying it. The other good case to know about for your clients is to let them know to change their beneficiary form once the quadro is done. The failure to change the beneficiary form will or could result in the benefit going to, say, the former spouse, even if the former spouse waived any interest to it in the divorce judgment. That was the fact pattern in Kennedy. In Kennedy, the parties divorced. There was a airtight, super clear waiver of the former spouse's interest in the participant's retirement benefit. Participant never changed his beneficiary form from the former spouse, who had been named in the form, and died. And the court determined that the plan has to be able to rely on its own plan documents to determine who should be the beneficiary, and so the funds went to the former spouse. This holding follows a 2001 United States Supreme Court decision, Egelhoff, that dealt with life insurance. So this is a consistent holding with the United States Supreme Court. So when we are done with helping people with their quadro needs, we let them know about Kennedy and let them know you've got to change your beneficiary form. We send that to the participant so he or she knows to do that. So just say it, just everywhere you can in your divorce judgment where it's appropriate, include a reference to awarding the former spouse an interest in the survivor benefits for the plan that the former spouse is being awarded. So now just some final thoughts. Again, includes the survivor benefit. I can't say that enough. Also, a good thing to know about is if the quadro isn't filed at the same time as the divorce judgment, which is most of the cases, you can serve the divorce judgment on the plan in an attempt to create a DRO, a domestic relations order, because that's a court order that in most cases the plans will place a hold on the account while they review it to determine whether it's a quadro or not. This does not apply to military or federal employee, but it may help create a hold until the parties get the quadros done for all the other plans out there. I just encourage everybody to do this work necessary pre-retirement to understand what benefits they're dealing with, to stop these post-judgment problems that come up afterwards, because your clients will be happier and you'll be happier because you won't have to deal with this again. And the courts will be happier because they won't have to deal with it again. So thank you for joining us today, and I'll see you next time. Thanks.